5 seconds to go. Start. One has a license to run around inflicting injuries that are sufficient to cause death in the ordinary course of nature and claim that they are not guilty of murder. If they inflict injuries of that kind, they must face the consequences, and they can only escape if it can be shown or reasonably deduced that the injury was accidental or otherwise unintentional. The first two elements laid down in paragraph 12 have been established in this case as the factum of bodily injuries, and its nature have been duly established. The question is whether the third element of intention to inflict the particular bodily injuries was present. As narrated by P.W.2, he, along with deceased Balveer Singh, were forcibly taken in a vehicle. When the vehicle reached unmetalled road, it was stopped. Thereafter, the accused banged deceased Balveer Singh flat on the ground, while the accused number 1 was holding Balveer Singh. The accused numbers 4 and 5 started assaulting deceased Balveer Singh. There was no scope for Balveer Singh to resist. Thus, he was taken out of the vehicle and was forced to lie down on the ground. Thereafter, the accused started assaulting him. Apart from the injuries on non vital parts, there was a fracture of 6th to 10th ribs on the right side, and the right lung was ruptured. Even the windpipe and food pipe were ruptured. There was an injury to liver. The cause of death, as certified by the board, was excessive bleeding due to injuries on vital parts like right lung as well as liver and the resultant shock. Going by the version of PW2, one of the accused held deceased Balveer Singh, who was lying flat on the ground, and at least 3 accused persons assaulted him. Therefore, it is impossible to say that the injuries on the chest, which resulted into fracture of 5 ribs and rupture of right lung, were accidental or unintentional. Therefore, even the third element was established. From the evidence of PW3, Dr. Jaspal, it can be gathered that the injuries on the vital parts like right lung and liver, which resulted into bleeding and shock, were sufficient to cause the death in the ordinary course of nature. Once the prosecution establishes the existence of the three ingredients forming a part of thirdly in section 300, it is irrelevant whether there was an intention on the part of the accused to cause death, as held by this court in the case of Virsa Singh Supra. It does not matter that there was no intention even to cause the injury of a kind that is sufficient to cause death in ordinary course of nature. Even the knowledge that an act of that kind is likely to cause death is not necessary. Stop.